Hello, and welcome to Connected with Latham, where we discuss ideas, developments, and trends shaping the global economy. I'm Ben Potter, a corporate partner in our Silicon Valley office, and in this episode, we're going to learn about the fast emerging trend of direct listings. To do that, there's perhaps no better source than Greg Rodgers, a capital markets partner in our New York office and a pioneer of the direct listing. So a major trend in the public capital markets right now is direct listings. Greg, before we dive into the topic more deeply, would you just please explain for our audience what a direct listing is?
A direct listing, at least the elevator pitch version of it, is listing a company's existing stock on a securities exchange, in both cases today it's been the NYSE, without conducting a primary offering by the company. So the company is not issuing new shares, but rather the pre-listing owners of the company are listing the shares that are already outstanding. Because there is no primary offering, there is no underwriting, and the banks involved act as financial advisors as opposed to underwriters. And as a result of that, there are no lockups, which provides a lot of flexibility on the sales of the stock.
So how do we get to this moment in time? Why is everyone talking about direct listings right now?
The history of the direct listing, I think, is actually pretty interesting. They are a brainchild primarily of a gentleman named Barry McCarthy of Spotify. Barry is a long-term industry veteran. Before being at Spotify, he was the CFO of Netflix. And before that, he was a principal at TCV, and before that, he was a banker. So he is a guy with a lot of experience with the U.S. capital markets and had a lot of opportunity to see how the normal way IPO worked. And like all really good innovations, the desire to do something different came out of a dissatisfaction with the status quo. In particular, I think, apologies to Barry if I'm putting words in his mouth, but I think he had sort of two significant gripes with the standard IPO process. The one, I think, is a view that various constituencies in the normal IPO process get an advantage of information over others, so that there's sort of an information disparity in the pricing that goes on. And then the second was that as a result of the information disparity, the pricing is inefficient. In particular, I think we see in a normal way IPO, particularly in the tech sector, the large pops in the stock price on the first day of trading, is sort of a sign that there was a mispricing there to the detriment of the pre-listing ownership. So that's the VCs and the management and other employees.
So distilling that down a bit, for our companies in the audience or management teams inside of companies, why should they be thinking about doing a direct listing vis-a-vis a traditional IPO?
I think it's worth to comment first on what the direct listing doesn't do for you. At least under the current iterations, it doesn't generate proceeds. 20 years ago, that would have been a showstopper for most companies. In today's day and age, though, with the deep liquidity in the private markets, we're seeing companies get to enormous scale just by accessing the private markets, so-called unicorn phenomena. But you can't pay rent in San Francisco with illiquid private stock very easily. So at some point, companies who are looking to get a real currency for their employees are going to want to access the U.S. listed capital markets. There's no better liquid markets in the world. And so the direct listing is a way to do that. And if you don't need money, but you still want to get your employees liquid public stock, you can do a direct listing. And you can do so in a manner where the pricing is more efficient than if you did arguably, if you did a traditional IPO.
Latham, and you, Greg, specifically, have handled both of the recent direct listings to date, Spotify on the company side and Slack on the bank side. So what were Spotify's goals in choosing the direct listing approach?
The goals, as presented to us, were quite clear from the beginning. They were interested in conducting a process that had radical transparency. And so what I mean by that is they wanted all of the market to have all of the information relevant to the valuation of the stock on an equal basis. So no models provided only to analysts or anything like that. They wanted to get everything out at once. That goal was accomplished by the information program we developed, primarily the Investor Day that we had, which I like to refer to as sort of the world's largest roadshow. Instead of meeting with large investor X in a conference room in Boston, instead we just did a video cast of a 4-hour presentation by the C-suite of the company to everyone who was interested. And so everybody had the same information. A little bit later, the company put out company-style guidance. So the idea was to create a level set of information equivalent to what's available for a company that's already public in advance of the first day of trading on the NYSE. And then the second goal was really dovetails with the first, which is to get efficient pricing in a pure supply-demand market, which occurred on the floor of the NYSE. And I think we saw a good result there too. The pricing was very efficient. The trading was very stable, much less volatile actually than a normal way IPO. So those were the two major goals, and I think both were achieved.
In terms of deal execution, were there any major issues that you had to get through in the course of getting the deal done?
I mean, that's where it was really exciting to be the lawyer in the room. The elevator pitch of what a direct listing is, I gave you, Ben, but to get from point A to point B took a lot of doing. The securities laws in the United States are sort of designed around an architecture of an offering, so where there's an actual sale of securities. Here, where there was a listing but no offering, we faced one of the larger square peg round hole issues I faced in my career. So there was a lot of discussion with the staff of the SEC about how to apply existing rules to our sort of novel situation. And I'd have to say, like, the staff was an amazing partner in the process. They were very open to the innovation. I think we had the real benefit of conducting this process at a time when the regulator was really open for innovation to encourage more companies to become public companies. So it was a real fun process. But just to give you some examples, I mean, we had to figure out how we had a good Section 10A prospectus without a price range. So, rulemaking guidance. We had to figure out our Reg M path, given that in the staff's view, we were conducting a distribution, but we had no real natural endpoint to it because there was no underwriting syndicate to break. The NYSE had to conduct a rulemaking process to allow direct listings to work under their rules, and we consulted with them on that. So there was just a ton of rules to govern, process to govern, concerns of the staff that we were taking, appropriate liability for what we were up to, concerns with the financial advisors, the banks, to make sure they were walking the line of what was permissible behavior on their part without becoming underwriters, a lot of that. So the Spotify process took about a year, and there probably wasn't a day during that year that I did not work on some aspect of the offering.
Looking at the landscape and into the future, we're getting tons of inbound expressions of interest and queries in Silicon Valley, both from the company side and from the venture capital side. How do you see the landscape evolving? Do you see a lot of these direct listings coming up? And how do you think the landscape is going to play out in the next 12, 18 months?
I think we will absolutely see more of them. I think Spotify was the perfect company to be the innovator in this space. They're a company that's built on innovation. Daniel and Martin had already disrupted the music business, so proposing to disrupt the IPO business with Barry alongside them, they were the perfect first mover. But then it's been fantastic to now work with another company, Slack, who's more of a normal way Bay Area tech company, and their direct listing has been viewed equally as successful. And that has really generated a ton of interest, particularly amongst the venture capital community, which makes total sense. As I mentioned earlier, the pre-listing owners are, I think, the real winners in the structure. So I really expect for the right company this to be a real viable alternative going forward.
Are there any considerations for companies who are considering doing a direct listing or weighing an IPO versus direct listing, and anything that they should be doing to prepare for a direct listing or continue to evaluate whether it's appropriate for them?
The good news there is the process for preparing to be a public company is largely the same. The only difference that I would point to is when you're doing your contract review, be extra attentive to terms that key off of references to, the big one is qualified IPO. The standard definition of qualified IPO refers to both a minimum proceeds to the company, and then it often includes the words underwriting or underwritten, neither of which are going to be satisfied by a direct listing. So that's just like a technical legal point, but in your series alphabet soup rounds or in your convertible notes or what have you that might have those terms in it, just be attentive to those.
Thanks again for your time, Greg. That was Greg Rodgers, a corporate partner from our New York office. Thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcast on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you'd like more information about the topics in this podcast, please email us from links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins, LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins, LLP. and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 885 3rd Avenue, New York, New York, 10022-4834. Phone number 1-212-906-1200.